Hello everyone, I hope you're doing okay. Today we're going to be looking at judicial powers of case management. In other words, what powers does the judge have during a court trial that helps them organise the court trial? So we're talking about this idea of organisation. So, I'm going to write organised. So, here we are in the study design. You see we're getting through it, and this is a little blurry today, but you need to know the judicial powers of case management. So, what is case management, which is the organisation of a case from start to finish, and what powers the judge has. And there are two main powers you need to be able to talk about today: the power to order mediation and the power to give directions. Okay, so the idea of judicial powers is, or the overall purpose of judicial powers is to facilitate a justice, fairness, equality, access, efficient, timely, and cost-effective resolution in a dispute. Okay, so again, as you've noticed with the theme for civil law, it's all about being as efficient, timely, and cost effective as possible when resolving a dispute. Now, there are two main powers that a judge will get um, during case management when they're organising the case. And these two main powers are the power to order mediation and the power to give directions. Now, a lot of students focus on the power to give mediation because that's easy and that kind of makes sense. Just be careful. I've seen a lot of questions where they've actually asked you to talk about the power to give directions. So make sure you practice that one as well. Okay, so the power to order mediation. Basically, the idea is that we should always be resolving a civil case in a prompt manner, a quick manner, an efficient manner. Okay, so one of the powers that a judge has is the power to refer people to mediation rather than going through a full court trial. The judge nearly always is encouraged to ensure that people are trying other dispute resolution methods before you actually go to a full trial. So normally at a directions hearing, for example, and we've talked about pretrial proceedings before, normally a judge will actually order a party to attend mediation first. Okay, again, that's that idea of a prompt resolution and an economical resolution. And really, with civil law, we're always trying to encourage an out of court resolution. So that's the first power. The second power is the power to give directions. Okay, I kind of like to think of this as power to give orders to the parties to do certain things with the idea of making the trial more efficient. Okay, so it's the idea of making a party do something by a certain time or do something specific or specify how something needs to be done or the conduct needs to be done in a civil proceeding. The idea is here that judges need to control the proceedings, so they need to be the overall manager of the proceedings to ensure that potential delays are minimized. And the judge can do directions in two different ways, okay? So they can order the party to do something before a trial, such as during a mediation, or during a trial. So as the trial is happening, the judge may require the parties to do a number of things in order to make the trial more efficient, more just, more speedy. So, what is the power to give directions? Okay, there are a number of directions that you can get before a trial. This might include conduct in the proceeding, so how you're actually behaving in the proceeding. Are you following court rules? It might be to give an indication of timetables and steps to ensure when the court date might happen, or timelines for undertaking certain duties, such as processing certain documents. It might be to encourage others to participate in any other dispute resolutions or order them to participate in any other dispute resolutions. So the judge will suggest that you go to mediation, you go to conciliation. It might be around ordering expert evidence. Okay, so maybe someone has been injured in a negligence claim and we need to have evidence around what the injury is. And the last one is to order the power of discovery. Okay, so that requires the judge to actually look at the parties exchanging documents and allowing them to actually look through those documents. During the trial, the judge has another set of directions that they can give. This may be limiting time taken by the trial, so ensuring that the trial isn't going to go on for months and months. It may be limiting how many witnesses actually at the trial. We don't want to have like 20 or so witnesses. That's a waste of time. So making sure that we actually have specific witnesses that are relevant to the trial. It may be about limiting party submission of certain documents or the duration of certain documents. And it may be about how evidence should be given. Okay, so how is evidence going to be presented to the court? Is it going to be verbal? Is there going to be written evidence as well? It may also include costs. So which party is going to bear the costs of the civil claim as well? Okay, so that's a very brief overview today. There are a little bit more detail to it, and we'll be talking about that in class as well. Okay, I will see you soon. Goodbye. If I can stop this.